The petitioner before my lords was the election petitioner before the concerned authority. The election was overturned because the recounting was held necessary. After recounting, I was held the successful candidate, of course, by a margin of 2 votes. The matter came before the single bench. The single bench upset the entire...
You were successful.
I was successful as election petitioner.
Right.
After that, the single bench overturned the entire proceedings because they held that I did not deposit the security for filing the election petition, the deposit amount, on time. Now, the MP, the rules which pertain to the deposit of security, they are slightly different, and their interpretation would be slightly different as compared to the usual representation of People's Act in Section 86.
Let's come to the impugned order.
Impugned order is annexure WA1, page 16.
Yes.
What the learned single judge holds is, the only issue raised by senior counsel is that Rule 7 of MP Panchayat's election petition corrupt practice, and that rules of 95, that deposit of security at the time of presentation of the election petition, the petitioner shall deposit with the specified officer a sum of 500 as security. Where the election of more than one candidate is called, separate and equivalent amount shall be deposited. Thus it is submitted, paragraph below that, the Honorable Division Bench has held that deposit of security is mandatory, and Rule 8 provides that if the provisions of Rule 3, 4 or 7 have not been complied with, the petition shall be dismissed by the specified officers. Provided that the petition shall not be dismissed under this rule without giving the petitioner an opportunity of being heard.
Have you served the copy of this appeal?
There is a caveat.
There is a caveat. We informed them in the morning also. We've just informed them that we are making a mention also at 4 o'clock. We've already informed them they should be here. When I requested this matter in the morning, Senior Counsel Mr. Gildial actually represents the other side. They've filed a caveat also. I mentioned that at 4 o'clock this matter we'll be requesting it. Just now also we tried to get in touch with his assisting counsel to inform that we are requesting as per the leave.
I think he has
40. So now
you are appealing it.
I'm appealing.
Yes.
Now our simple submission is, Rule 8, that is the rule in question, which empowers the competent authority to dismiss the election petition at the outset in violation of Rules 3, 4 and 7, has got a proviso. That proviso says that provided that the petition shall not be dismissed under this rule without giving the petitioner an opportunity of being heard.
These two orders, 30th September 22 and 11th at 2022, passed by which authority?
They were passed, by the subdivisional officer acting as the election tribunal.
Election tribunal.
Yes. Then after that, on 11/10/22, the recounting was held. On merits, the ground was that since the electricity was not available, that is why chances of certain miscounting would have been there. Petition was allowed on that ground. And ultimately, on recounting, it was held that I was the successful candidate. The only reason why this was upset was because Rule 7 mandates that at the time of filing of the election petition, I am supposed to deposit a security amount of 500 rupees per candidate. Now the argument was that at the time of filing of election petition, that was not given. That was given later. Now, based on that, the learned single judge held that the entire proceeding goes. Now, that would have been true, my lords, had the proviso to Rule 8 probably not existed. Because in contradistinction, if we see Section 86 of the Representation of People's Act, which provides for a very similar thing, that if these three contingencies are not met, petition can be dismissed. Yes.
My respected submission is the Honorable Single Bench is pleased to pass the order on relying the Divisional Bench order passed by this Honorable Court in the Sarla Tripathi case, in which the Divisional Bench is pleased to have rules 7 and 8 as the mandatory, and the court fees must be submitted before security deposit must be submitted before the along with the filing the election petition. It is there are so many judgments. One judgment is pleased to rely by the Divisional Bench in a Sarla Tripathi case.
Sarla Tripathi has been relied upon.
Yes, this is the Sarla Tripathi case. And there is the provision under Rule 7 and 8 model. Without depositing the security amount, election petition cannot be entertained.
That's true, Manoj. I don't dispute that. It's a mandatory provision. I don't dispute that.
What you want to say?
My contention is, Manoj, that in the instant case, the security deposit, my lords, there's a technical reason. It finds place in the order impugned. If my lords will just have annexure W82, particularly, my lords, page 32 of the petition. The amount on the date of filing of the election petition, there was a technical error because of which the deposit could not be made. The deposit was made thereafter. This objection was taken by them in their return, which they filed to the election petition. That objection was dealt with by the learned electoral tribunal, and that objection was overruled. My contention is, by virtue of the proviso, a mandatory provision true exists, but the manner in which the learned single judge has dealt with it is that it is ipso facto, it has to be cast out the election, the election petition. The fact that that proviso exists offers the fact that I have been given an opportunity of being heard implies that there is something for me to say.
Or this fee to be deposited, security to be deposited through online.
No, it's through bank challan.
Right.
Bank challan.
So why you could not make?
Beg your pardon?
Why?
That's in the order itself, Manoj. There was a technical error that day. That's what the election tribunal notes.
Where it is?
Page 32, part of annexure WA1. A1, sorry. Manoj has page 32?
32, yes. A2.
Yes. My lords may just, sorry, this is page 33, man.
Yes.
My lords will find a category G in the
G,
yes. The fourth line from the top it submits. इस संबंध में याचिकाकर्ता का उत्तर था कि याचिका प्रस्तुत करते समय तकनीकी त्रुटि होने से चालान नहीं कटवाया, इस हेतु उन्होंने एक आवेदन पत्र इसके साथ न्याय शुल्क जमा कर दिया है। चूंकि याचिकाकर्ता द्वारा न्याय शुल्क जमा कर दिया गया है और न्यायालय द्वारा न्याय शुल्क बाद में स्वीकार कर लिया गया है, अतः प्रति याचिकाकर्ता का यह दलील
who is established that there was a तकनीकी त्रुटि?
This is a finding given by the tribunal, my lord.
So किस base? What was the base? आप तो कह सकते हैं तकनीकी त्रुटि, but what base? वो तो बैंक बता सकता है कि yes there was a some error.
That's there.
तो उसमें क्या है आपके पास?
Now, Malas, in that reference, in all fairness, Malas, there's nothing. We fairly admit that it was a technical error. I don't have the details of the technical error, but it was later on paid. What I submit, Malas, legally is slightly different. The proviso says that I have to be heard before the petition is dismissed. There are two implications to that. Of course, first thing that I have to be put to notice. Secondly, that there is some explanation of mine which has to be considered. Now, whether that explanation is right or wrong, the query which is falling from my lords, I most humbly submit that's a very valid query. Had, considering the answer to that query, the learned single judge have dismissed my petition, I would not have had much of a case. What the learned single judge does is, the learned single judge says is, it's mandatory, irrespective of whatever explanation, since you've not deposited, it has to go. My only submission is that.
Have you taken instruction from your client? What was the exact technical error?
I'll do that.
बैंक चालान देना था लिया आपने.
Yes, ma'am. That could have been. I'll just seek specific instructions in that regard.
ठीक है. इसको make it tomorrow. Tomorrow.
Deeply obliged.
इसमें ऑर्डर भी दिया है.
Serial number 28. Your Lordship, may kindly give me